Hey, I'm Nancy Cavey, National ERISA and Individual Disability Attorney. Welcome to Winning Isn't Easy. Before we get started, I've got to give you a legal disclaimer. This podcast is not legal advice. The Florida Bar Association tells me that I've got to say this, but once I've said it, nothing prevents me from giving you an easy-to-understand overview of the disability insurance world, the games that disability carriers play, and what you need to know to get the disability benefits you deserve. So, off we go with today's episode. Disability carriers can be excessively sneaky. In fact, they often will cherry pick medical records and scrape evidence from files that supports their claims denial, all while ignoring the mountains of evidence that suggest you are indeed disabled. In this episode, I'm going to be talking about three things. First, how Reliance Standards doctors cherry pick medical evidence to justify the denial of a colitis and Crohn's disease disability claim. Unum's cherry-picking medical records to justify a claims denial in an ankylosing spondylitis case, and how Hartford cherry-picked the medical records when the policyholder doctor said that he was hopeful that the policyholder could return to work in 6 months. You can see that this is a strategy that every disability carrier employs in creating reasons to deny claims. And it doesn't matter who your disability carrier is, there are lessons to be learned from these cases. So let's take a break for a moment before we get started in this week's episode. Welcome back to Winning Isn't Easy. Let's talk about how Hartford cherry-picked medical records when the policyholder's doctor said he was hopeful that the policyholder could return to work in 6 months. Nothing's going to stop a disability insurance carrier from looking for reasons to terminate a long-term disability claim, even if the policyholder has been receiving benefits for over 20 years. One of the games that disability carriers play is to cherry-pick a doctor's statements, and then take those statements out of context to justify a claim termination, betting that they can win in federal court. So let me tell you the story of Mr. Corelli, who worked as a vice president for Bear Stearns until December of 1999. Unfortunately, he was injured in a catastrophic car accident. He was left permanently disabled. He underwent many surgeries, sustained or had problems with side effects of medication. He had a stroke. He began to suffer from depression. He was a mess. And Hartford paid him his long-term disability benefits through 2019. In 2019, one of his treating physicians, Dr. Francis, said he was hopeful that Corelli could return to work in 6 months if certain treatments and changes in medication proved effective. That's a lot of ifs. That did not deter Hartford from terminating benefits after the change in treatment and medication were not successful. Ultimately, the court got involved, and it was Judge Sessions of the United States District Court of Vermont. And I'll tell you, Judge Sessions was not impressed. I think this case is a classic textbook example of claims denial tactics. And let's talk about that. One of the basic principles in ERISA is that a disability carrier has to justify a claims termination based on a change in medical condition. Now, Hartford seized on these comments in the treating provider's records and how the provider completed the attending physician statement form. And they claimed, of course, that there was improvement. Now, if Corelli had been represented by an experienced ERISA disability attorney who was monitoring his claim, the attorney, I'm sure, would have picked this up and would have dealt with this. But Corelli was not represented at this point in the claim. Now, in this case, the medical records continue to document that he suffered from significant pain because of an L3 to L5 fusion, and he had a limited ability to sit, stand, bend at the waist, kneel, crouch, and reach above his shoulders. The trouble obviously began when Dr. Francis noted in May of 2018 that notwithstanding these difficulties, it would be a good idea to reassess Corelli's medical condition since his treatment and medication were going to be changed. He suggested a return to work date in 6 months, and Hartford gleefully seized on this language to justify a claims denial. Now, if I had been Corelli's attorney, I would have read that record and I would have been on the phone with Dr. Francis saying, whoa, wait a second here. You need to clarify that this is just a recommendation. It's a hope. It's a speculative hope. And I'm not changing the opinion that he's disabled, but I'm willing to, try to give him this additional treatment to see if it will improve his functionality. Now, Francis had made these treatment recommendations primarily based on developments in medical literature and attitudes towards the use of opioid medication. In other words, he wasn't really wowed about the level of medication that Corelli was taking or how long he'd been taking. And this was a way, in my view, to cover his rear end. That's just my personal opinion. But after Francis made this comment, Corelli suffered a stroke, and then obviously he became depressed. And that just compounded all of his medical problems. But that didn't deter Hartford seizing on Dr. Francis's recommendation. Now, Francis subsequently noted he had planned on evaluating Corelli's ability to return to work once it was determined if Corelli's pain level had improved with the change in medication and treatment. Of course, Corelli advised that the pain hadn't worsened, but it hadn't improved. So it was stable, but it was still disabling. As a result, Francis confirmed that Corelli's level of disability hadn't changed and his condition was permanent with no hope of improvement. But not to be undeterred, Hartford sent Francis a letter in October of 2018 inquiring whether Corelli could engage in sedentary work that involved sitting most of the time. That could also involve walking or standing for brief periods of time. Dr. Francis took the bait again and opined that Corelli could do sedentary work on a full-time basis. He also completed an additional attending physician statement form documenting that Corelli could sit, stand, or walk 1 hour at a time or sit for 4 out of 8 hours out of a day. Now, if Corelli had been represented, his attorney would have headed this off at the past, would have had Francis clarify his opinion and maybe recommend a functional capacity evaluation, but make it clear that Corelli couldn't work. So what ultimately happened was Hartford justified the claims denial based on Dr. Francis's notes and the APS form. And quite frankly, Dr. Francis did not do Corelli any favors in this case. Fortunately, Corelli became represented. Corelli appealed and also underwent a functional capacity evaluation in January of 2020. That found that he could sit only 1 hour a day for a total of 3 hours to 4 hours in an 8-hour workday. He could stand or walk 10 minutes at a time for a total of 1 hour during an 8-hour day, and he could only occasionally do lifting and bending. He had the stamina to only do work 2 to 3 hours per day. And during the functional capacity evaluation, his pain level fluctuated between 5 and 7. That was submitted. And then, of course, Hartford said, we're not going to give up this denial so easily. They attacked the functional capacity evaluation, and they were critical of the FCE carrier's methods of evaluating Corelli's conduct during the course of the FCE. Now, why was that important? Corelli had received 2 failing scores on the grip strength test, and Hartford noted that the inconsistency of effort was poor. So what Hartford was arguing was, look, this FCE is invalid, and it's based on the self-reports, which were not validated via testing. Now, it should be noted that this FCE was less than sedentary, which means that Corelli couldn't perform the sedentary work that Francis had suggested he could do. Fortunately, Francis signed off on this FCE, but then, as I've said, Hartford hired a liar for hire who disagreed with the FCE and agreed with Dr. Francis's October 2018 confirmation that he could do sedentary work on a full-time basis. So Hartford refused to change its position. Ultimately, this case ends up in federal court. This is the case of Corelli versus Hartford Life. The judge noted that Dr. Francis had revoked his opinion that Corelli might improve, and had informed Hartford that Corelli was still disabled from all professions, despite his earlier optimism. The court rejected Hartford's arguments regarding the FC, noting that while the validity testing and objective measures would have been desirable, the court couldn't dismiss the subjective self-reporting as presumptively invalid. In a dig to Hartford, the court noted that if Hartford was using the grip strength testing to suggest that the FCE providers' methods were flawed, or that Corelli was incredible, or both, that was a very crappy way to attack the validity of the FCE. Because the court also noted that the FCE reflected a thorough examination performed over 4 to 5 hours. There were a variety of assessment methods, and the consistency of effort was evaluated by several means. And I will tell you that grip strength testing is, in my view, and based on my experience, not a really valid measure of a person's effort during the course of a functional capacity evaluation. You can do heart rate monitoring testing, which I think is, quite frankly, more effective and I think shows consistency of effort. Now, the court wasn't done with Hartford. The court looked at the consistency of reporting over 20 years and said, look, there's no evidence or suggestion of malingering in these 20 years of records, so I am not going to buy your attack on his credibility. The court concluded that Hartford had abused its discretion because Corelli's medical history clearly established that since the car accident, his treating physicians had all maintained he was unable to perform full-time work. His condition was permanent, and the records did not justify a claims denial on the basis that there was any change in his medical condition. And taking that little slice of, well, geez, I'm going to change his treatment and change his medication, and I think there might be some improvement, was at best speculative. Fortunately for Corelli, the judge reversed the claims denial and awarded benefits. But here's the rub. It took years to correct what could have been corrected if Corelli had an ERISA attorney on retainer to monitor not only his forms, his medical records, and work with his physicians to clarify and clean up these misleading statements that an experienced attorney knows that disability carriers like Hartford or Unum, you name it, are going to seize on to justify a claims denial. It's cherry picking 101. I hope you've enjoyed this week's episode of Winning Isn't Easy. If you've enjoyed this episode, please consider liking our page, leaving a review, or sharing it with your friends and family. Please subscribe to this podcast. That way you're going to be notified every time a new episode comes out. Please tune in to next week's insightful episode of Winning Isn't Easy. Thanks.